All right, sounds good. Well, good afternoon, everyone. Welcome to the Assembly Committee on Privacy and Consumer Protection. We're going to start as a subcommittee because of the lack of a quorum, but yet we're still waiting for authors from the Senate. I understand that they're still having their caucus. So we'll start the hearing as soon as the first author gets here. So thank you for your patience.
Is it ready for me?
Looks like we have Senator Leno with us. Anytime you're ready, Senator. We've been waiting. We have item 1, SB 868.
Thank you, Mr. Chair. I thought I was coming here to sign in, but I'll take it.
Yep. Correction, SB 1121.
That's right, 1121. So, as the committee may know and may remember, we authored a bill with bipartisan co-authorship a couple years back, SB 178, which created the California Electronic Privacy Communication Act. The idea behind it was that the same constitutional protections that should protect a piece of mail in your mailbox or a letter in your filing cabinet, electronic communications, digital communications, emails, texts, even your location information should be protected, and now requires that there be probable cause of illegal behavior going on so that law enforcement would get a warrant to be able to access that information. Clearly, we are now communicating and will continue to communicate ever more in a digital fashion. Not unexpectedly, there have been some unintended consequences, and the purpose of this bill is to deal with those unintended consequences, so it is indeed cleanup of our Cal-ECPA bill, SB 178. So, for example, it clarifies that electronic device does not include the magnetic strip on the back of your driver's license so that CHP can swipe your driver's license as needed. It also provides that emergency responders may access location information when someone calls 911. That seems pretty obvious. Makes it clear that jails can record conversations on inmate phones with proper notice. It also clarifies that there's nothing in Cal-ECPA that limits the authority of a government entity to compel an employee to return a device that the government entity owns. It also provides that notice in an emergency must be provided within 3 court days rather than 3 calendar days, allows for the search of contraband phones found in jails, and also allows DAs to disclose sealed information for discovery purposes without getting a court order. The bill has no opposition, no cost to the state, and I ask for your aye vote.
Thank you very much. We're still operating as a subcommittee. Now let's go to our first witness, please.
Mr. Chair, members, Francisco Lobaco. On behalf of the American Civil Liberties Union, the senator has laid out the basic gist of the legislation. It is cleanup intended to fix some of the unintended consequences of last year's bill. I'm happy to be up here with probably my last bill with the California District Attorneys Association, so we urge you to move the bill forward. Thank you.
Thank you. Next witness, please.
Sean Hoffman with the California District Attorneys Association. I feel like we should probably take a selfie to memorialize this partnership. But as the senator noted, this has been a bill that has been the product of good discussions with all of the stakeholders from SB 178 to identify, where it wasn't running smoothly, how can we help facilitate that process. And so I think, the product that you have before you today is the result of several weeks and months of those discussions, and is a good bill that is worthy of everyone's support.
Thank you very much. Just to clarify, are you accepting the amendments as suggested? Thank you. Additional witnesses in support of the bill, please step forward.
Samantha Corbin on behalf of Electronic Frontier Foundation, one of the co-sponsors of originally of SB 178, would like to thank all of the stakeholders as well as the author's office and his staff who worked tirelessly on addressing these concerns, and encourage your aye vote. Thank you.
Thank you much. Additional supporters? Seeing none, let's go to opposition. Seeing none, questions and comments from the panel. Committee? Mr. Cooper, go ahead.
Yeah, I have a couple of questions for the CDA individual rep. This is a great start, but I've been told there are a number of other things that there are issues with, particularly from your CDAA. Can you address some of those?
Yeah, I mean, this bill, as you said, it's a start. It addresses what the stakeholders who met, which involved CDAA, ACLU, EFF, some of the other law enforcement organizations. This was what everybody kind of agreed was a problem. These were the problems that everyone agreed needed to be fixed, kind of the low-hanging fruit, so to speak. There are still outstanding issues dealing with search and seizure waivers for individuals who are on supervised release. Off the top of my head, that's sort of the big one that's still hanging out there. But to your point, this does not fix all of the unintended consequences of SB 178, or perhaps intended consequences of SB 178. There are things that we could, we would like to see changed, and things that wouldn't surprise me if we had tried to advance legislation to that end next year or the year after that. This was really just an opportunity for everyone to sit down on both sides and identify things that were very clearly unintended consequences that demanded a quick and easy fix, and that's what we've got here with 1121.
Right, and your organization was neutral on this bill, correct?
That's correct. We opposed SB 178 initially through several rounds of amendments and a number of conversations and meetings with the author and the proponents of SB 178. We ultimately got to a position after the bill was heard, I think, in this committee last year. There were amendments taken that sufficiently resolved our concerns on that bill to the point that we were able to move to a neutral position along with a number of our law enforcement partners.
Okay, and I want to thank the author for bringing this forward and addressing some issues, but for instance, I'll bring a few issues up. A kidnapping case in Vallejo. A suspect fled the scene. They found his phone. They searched his phone, and that's the only way they knew who he was. And right now, his attorney's arguing they can't search his phone. That's one issue. Someone on probation or parole, when you're on probation or parole, is those terms, you're subject to search and seizure by a peace officer. Basically, you're agreeing not to be in custody, to be on probation or parole. We've had issues with that. I was contacted by several school districts, who issue district-purchased iPads to children in high school, and they're under the impression that they cannot look at these iPads to make sure these children aren't going to, pornographic websites or things like that. So I think the CDA is aware of some of those issues. It's much broader with the issues like that, and there's a good chance that we may lose that case. Well, law enforcement may lose that case in Vallejo with the suspect's phone, who flees the scene and really has no right even when he drops his property there. So I would hope this is a great start, Senator Leno. I hope there's some more work to do to help clean this up, because we're hearing from quite a few folks of the unintended consequences. So I will be voting to support your bill. Like I said, I'm glad you're bringing it back. I want to thank you for that. It's a great start, and hopefully CDA will be more engaged this time and look very closely at some of the issues associated with it, because, in my opinion, you guys dropped the ball and didn't really vet it as good as you should have.
Mr. Chair, if I may respond just briefly.
Absolutely.
I certainly don't know the details of the Vallejo case, but if you've got a suspect, you easily get a warrant like that. And so then you go through the phone, no problem there. With regard to children and iPads in schools, you can limit what they can access so kids are not accessing pornography. That is a simple fix that the school providing the instruments can provide. And then we did take an amendment in this bill that clarifies that nothing in CalECPA limits the authority of a government entity like a school to compel an employee to return a device that the government entity owns. So that's really not a concern either.
I'm sorry, Senator, but I think on the issue with the iPads, still just to go out and search it and access, to figure out, make sure these kids aren't accessing sites they shouldn't be accessing, the way the school's reading it, and we're talking district attorneys for the school districts, the way it's being interpreted, not just one, but in many school districts, that they cannot examine these iPads because they're the kids' iPads. And the same thing with the I think more importantly, with the phone that was dropped, it's you can get a search warrant, but that requires the officer going back, typing out a search warrant, going and finding a DA to sign that search warrant, going and finding a judge, versus taking that phone and using a device to gain the information and gain it. So if you're talking in exigency, I think a kidnapping exigent circumstances, it's much quicker to do that than to get a search warrant, which may take several hours.
Thank you for reminding me. There is also the exemption from CalECPA altogether for an emergency situation, so they can just go ahead and do it.
Right, but it's being challenged by attorneys, so we know how attorneys are. Some are good, some are bad. But the issue is it's still cropped up. But like I said, I'm not here to beat up on your bill. I'm glad you're doing it. It's a great thing, but there's still more cleanup language that's needed.
Well, thank you very much for your input. I encourage the author to continue working. If there's any loophole that we need to close, then we definitely should do that.
I just want to, as in my close, just put a good word in for the California District Attorneys Association. I ask for your aye vote.
Thank you very much. Since we don't have a quorum yet, when we do, we will move your bill along. Okay. Thank you for being here. Next, we have Senator Jackson. Welcome.